Thank you, sir. Further to his answer of 10th of September 2013 and his subsequent media release, will the Chief Minister clarify for the Assembly the full and complete costs arising from the secret court proceedings against former Senator Stuart Sivray? And will he clarify what percentage of the costs, if any, were paid for by the four individuals themselves?
Chief Minister.
Thank you, sir. As explained at the last state sitting, the costs of bringing the case incurred by the Data Protection Office amounted to just over £387,000 for a 6-year period from 2008 to September 2013. The additional costs of the Data Protection Commissioner's Office were met by court and case costs. The four individuals did not fund the court costs. The only additional costs to the court service were £14,010 the bailiff's chamber. There were no additional costs incurred by the judicial greffe.
Supplementary.
Yes, sir. I must ask, is the Chief Minister happy to stand by that figure? Because I think I can come back to the Assembly with a rather different one very soon.
So I've got no reason to doubt the figures which I've quoted. They've been provided to me, respectively, by the court service. As I said, they are additional costs. They don't include the sunk costs of the normal running of the court service.
So a supplement, that is quite clear that it should be highlighted in the cost in their entirety, and really the answer is not good enough. Could the Chief Minister not go away and come back with a proper answer?
So it is a proper answer. The budget for the court service is approved as part of the normal MTF, what is now the MTF process, and is in the public domain, and the court service runs within those budgets, albeit of course there is court and case costs, and I've discussed what funds came out of court and case costs for this particular case, sir.
Mr. Higgins.
Yes, thank you, sir. Personally, I don't think it's good enough, the answer that the Chief Minister has given. This case was held in secret. There's been all sort of fudges, sort of non-answers given by assistant ministers and all sorts about what's gone on here. How many other cases have taken place? We know that there's been other breaches of the data protection law. Can the Chief Minister give us an assurance that there's been no other cases funded in this way or done secretly in the past?
So, of course, hopefully one would not expect me to be aware of all the cases going before the courts. That's not within my remit, and therefore I've had no reason to ask that question and be aware of any other such case. I've been asked in this instance. I've taken the exceptional step of releasing the costs incurred by the Data Protection Commissioner's Office because of public interest. And I don't think I need to go any further, sir.
Supplementary, sir. You say in the public interest, but was it not the Data Protection Commissioner who invited these people to come to her department and to discuss with lawyers about bringing a case in this particular instance? You know, why was the Data Protection Commissioner inviting people to come in and form an action and then the public pick up the bill for it? When other people, where there's been data protection breaches, have not been given any financial assistance whatsoever?
So it's my understanding that the judgment made it perfectly clear that the Data Protection Commissioner acted within her remit and in accordance with the law, and members of this Assembly should be satisfied with that. It appears to me, sir, that actually some members are not satisfied with the law. If members wish to see changes to any piece of legislation, that's perfectly within the remit of a legislative assembly, of which we are, sir.
Mr. Southern.
Thank you, sir. How much money was taken from the court and case costs funds to pay for this case?
So I've answered that on a previous occasion, and I've just answered it again this morning.
I understood the Chief Minister to say what he said earlier, that he had answered the question earlier this morning, but Deputy Teddy.
Thanks, sir. The Chief Minister's asked whether members are happy and they can bring their own amendment. But is the Chief Minister happy that a precedent now seems to have been set that in the past, a case which seems to be a libel case of defamation, data protection has been used because the test, of course, is that some content on a website is found to be harassing. And should not the test be whether or not it is actually factual or not, sir? Because something can be harassing and it can also be true. And so is the Minister concerned that, again, that public money is being used, and we've created a precedent here that anybody on any site who doesn't like what's been written about them can now have their court cases funded and their names removed by the taxpayer?
Sir, I'd have thought the members of this Assembly were fully acquainted with the data protection law, because they are data, they have licences as individuals to handle data, and the way that we handle data is very important, and the way that other individuals and reporters and media, etc., handling data should abide by the data protection legislation. If they're not doing so, then they should expect to suffer the consequences of not complying with that piece of legislation. The court, as I understand it, made it quite clear in its findings that damage had been caused to those individuals in the way the data had been handled.
But, sir, supplement, isn't the only issue here that nobody had heard about this data protection law being used in what would otherwise be a libel case, apart from the first time it's used that we know about, when it's used as a very high-profile figure who's an enemy of the establishment, and that is how it's perceived? Will the Minister speak on that issue and talk about whether that recourse will be available to anybody else who wants to take action about defamation?
So it was a data protection case, and it was connected with data handling, and that is very different from libel, sir.
Can I remind members that this is a question about the costs which have been incurred? Mr. Higgins?
It's still about cost, sir, but it's also about principle. We have in this House at the present time a member who broke the data protection law and was not prosecuted. Why is it that there's one rule for one person, not for another? And I can't see how the Data Protection Commissioner did not bring a prosecution in that case when it was cut and dried breach of data protection law.
Well, that's not a question, it appears.
Does the Chief Minister agree there should be a consistent standard across the board?
Sir, let me say I've got no reason to doubt whatsoever that the Data Protection Commissioner nor our prosecution service act in any other way other than consistent and in line with what we would expect around making appropriate prosecution decisions, sir.
Final supplementary, Deputy Trevor.
Certainly, sir. Well, I've got a nice big file here for next time about yet another data protection breach not prosecuted. But given the Chief Minister's answer in his press release, I believe he expressed his contentment that with the way the process had been unfolded against former Senator Silvery. Could he tell us, is he also content that other individuals are actually denied by the Data Protection Commissioner's Office to bring the same sanctions processes against individuals, one of the individuals involved in the case? Indeed, a gentleman who's got numerous complaints against the police and was actually found guilty of making death threats to the family Stuart Sivray lived with. Where's the consistency in that? Is the Minister content? And can he please give us a proper answer instead of saying that he's quite happy to accept anything the Commissioner says?
So it's not me saying that, it's the court that said that, and I stand by the court's decision in this regard, sir, and I believe that this Assembly should too. We'll shortly be coming today onto a proposition to very appropriately on the back of a proposition from Senator Farnham to make sure that judicial policy and budgets have appropriate executive oversight. Part of that proposition, rightly, sir, should mean that members of this Assembly don't involve themselves in individual cases and get involved in operational matters. The court quite clearly said that the Data Protection Commissioner had acted appropriately and within the bounds of the law that she administers, and the members of this Assembly should be satisfied with that, so not try and second-guess every single decision made by either the Data Protection Commissioner or the Prosecution Service, sir.
So, final supplementary, because the Minister hasn't really answered my question. I can say for a fact that this is what happened because I am that individual who requested support against an individual who runs hate sites. Indeed, He was one of those behind the hate site that the email stolen by Deputy Power from the Deputy of Greville ended up on. A pro-child abuse cover-up website. Where's the consistency? Why is the Chief Minister content, as it's his responsibility, so he tells us?
So I'm not sure that it's appropriate for individual members to be referring to their own individual cases and trying to use this assembly to get a hearing about decisions which have been made by appropriate authorities, sir.
So, well,
Principles, sir.